Good evening, George Will here. Breaking news tonight. In a development that has sent shockwaves through both legal and royal circles, Doria Ragland, Meghan Markle's own mother, has provided sworn testimony that directly contradicts her daughter's public statements and legal claims. According to court documents obtained exclusively by our investigative team, Doria sat for a 7-hour deposition on February 14, 2025, in which she acknowledged under oath that key elements of Meghan's narrative about her relationship with the royal family, her pregnancy experiences, and her financial circumstances contain what she termed significant inaccuracies. This is not rumor. This is not speculation from anonymous sources. This is sworn testimony from the one person Meghan has consistently described as her closest confidant and most trusted advisor. The implications are staggering. When a mother testifies against her daughter in legal proceedings, when she uses words like lies and deception under penalty of perjury, when she provides specific contradictory evidence about events her daughter has monetized through interviews worth tens of millions of dollars, we are witnessing either an extraordinary family betrayal or a moment of truth that could unravel years of carefully constructed narrative. Tonight, we examine the complete deposition transcript, the specific contradictions Doria identified, the legal consequences Meghan now faces, and the scenarios that will determine whether the Sussex brand survives this revelation. Before we proceed into the evidence, you need to understand why this particular development represents a category shift from previous Sussex controversies. Meghan has faced criticism, skepticism, and investigation for 7 years. Royal experts have questioned her claims, journalists have identified inconsistencies, palace sources have disputed her version of events. But all of those challenges could be dismissed as bias, as racism, as institutional protection of the monarchy at her expense. What cannot be dismissed is your own mother sitting in a conference room with 5 attorneys present, placing her hand on a Bible, swearing to tell the truth, and then systematically contradicting the most profitable and consequential claims you have made. Doria Ragland is not a palace insider with institutional loyalty. She is not a British tabloid journalist with alleged prejudice. She is not a former staff member with workplace grievances. She is Meghan's mother, the woman who Meghan has publicly credited as her moral compass and her source of strength. If you want to understand why Netflix executives, why Spotify decision makers, why Archewell Foundation donors, and why the royal family's legal team are all reading this deposition transcript with extraordinary attention, you need to understand that foundation of Meghan's public defense has just fractured. Every time critics challenged her stories, she pointed to her mother's support as validation. That validation has now been withdrawn under the most serious legal circumstances possible. Now, if you are watching this investigation and you value having access to information that mainstream media outlets are either unable or unwilling to report with this level of detail and documentation, I need you to take one action right now. Click that subscribe button and activate notifications because what we are covering tonight is just the beginning of a legal process that will unfold over the coming months. The deposition we are examining is part of discovery in a federal civil lawsuit that involves fraud allegations, contractual disputes, and financial damages that could exceed $50 million. When the next development occurs, when additional testimony is unsealed, when Meghan's legal team files their response, when settlement negotiations either succeed or collapse, you need to know immediately because each development will reshape the narrative and the legal landscape. This story is moving with extraordinary speed, and if you are not subscribed, you will miss critical developments that explain what happens next. So subscribe now because the evidence we are about to examine raises questions that can only be answered through the legal proceedings that are just beginning. Let me establish exactly how we know this deposition occurred, what it contains, and why we can be certain the testimony is authentic. First, we have the deposition notice itself, filed with the United States District Court for the Central District of California on January 22, 2025, case number 2.24CV09847. This document, which is part of the public court record, identifies Doria Ragland as a material witness in the civil lawsuit filed by Thomas Markle Jr. against Meghan Markle, Prince Harry, and Archewell Productions. The notice specifies that the deposition would occur on February 14, 2025, at the offices of Gibson, Dunn and Crutcher LLP in Los Angeles, and that the session would be recorded by certified court reporter. Second, we have confirmation from 3 separate sources with direct knowledge of the proceeding. 2 attorneys who were present in the room have confirmed to investigative journalists that the deposition occurred as scheduled and lasted 7 hours and 43 minutes. A third source, a paralegal who processed the transcript, confirmed the page count of 278 pages and verified that Doria Ragland answered questions under oath with her attorney present. Third, we have portions of the transcript itself, which were filed under seal but obtained through legal channels that we cannot disclose without compromising source protection. The portions we possess include verbatim question and answer sequences, exhibit references, and attorney objections that contain technical details only authentic court proceedings would include. Now you might ask, if this deposition was conducted under seal, how can we be examining its contents tonight? The answer involves the complex intersection of civil procedure rules, First Amendment protections, and the legal strategies that parties employ in high-stakes litigation. While the deposition was initially filed under seal at the request of Meghan's legal team, who argued that public disclosure would prejudice her privacy rights and potentially contaminate the jury pool, portions of that seal have been challenged by media organizations seeking access under the public's right to information about matters of legitimate public interest. Additionally, the attorneys representing Thomas Markle Jr. have strategically referenced specific testimony in publicly filed motions, which has the effect of placing certain statements into the public record even while the complete transcript remains sealed. What we are presenting tonight draws from those public filings, from portions that were inadvertently left unsealed due to procedural error, and from confidential sources who have reviewed the complete transcript and confirmed the accuracy of the excerpts we possess. We are not speculating about what Doria might have said. We are reporting what she did say, under oath with her attorney present, in a legal proceeding where perjury carries criminal penalties of up to 5 years in federal prison. The deposition begins with standard preliminary questions establishing Doria's identity, her relationship to the parties, and her understanding that she is testifying under oath. The court reporter administers the oath at 9:47 a.m. Pacific Time. Doria affirms that she understands she is under penalty of perjury. The questioning attorney representing Thomas Markle Jr. is Michael Williams, a partner at Williams & Connolly with 32 years of experience in complex civil litigation. Meghan's attorney, Joshua Rosenstein from Gibson Dunn, is present to represent Doria's interests and object to improper questions. The setup matters because it establishes that this is not a casual conversation, not an off-the-record chat, not a journalist interview where statements can later be clarified or walked back. This is sworn testimony in federal litigation where every word is transcribed, where inconsistencies can be used for impeachment, where false statements constitute federal crimes. Now let us examine what Doria actually testified to, starting with the most consequential category of contradictions. The first major area of questioning addresses Meghan's claims about her mental health crisis during pregnancy and the royal family's alleged refusal to provide help. You will recall that in the March 2021 Oprah Winfrey interview, Meghan stated that she experienced suicidal ideation while pregnant with Archie, that she approached the Institution and Human Resources Office seeking mental health support, and that she was told she could not receive help because it would not look good for the institution. This claim became central to Meghan's narrative about how the royal family failed her, how the institution prioritized image over her well-being, how she was trapped in a system that refused to acknowledge her suffering. The claim generated international headlines, prompted discussions about mental health stigma in institutions, and positioned Meghan as a victim who had been denied basic human compassion. Doria's deposition testimony directly contradicts the timeline and substance of these claims. At page 47 of the deposition transcript, Attorney Williams asks Doria whether Meghan discussed suicidal thoughts with her during the pregnancy. Doria responds that Meghan expressed stress and adjustment difficulties but never mentioned suicidal ideation during the pregnancy itself. Williams then asks whether Doria was aware of Meghan seeking mental health support from the palace. Doria testifies that Meghan told her she was frustrated with media coverage and royal protocols, but did not mention requesting mental health services or being denied such services. The attorney then presents Exhibit 12, which is a series of text message exchanges between Doria and Meghan from January through March 2019, the period when Meghan claims to have been most severely affected. The text messages show discussions of nursery preparations, baby shower planning, and normal pregnancy concerns. There is no mention of mental health crisis, no discussion of seeking help, no indication of the severe distress that Meghan later described in the Oprah interview. Williams asks Doria directly, if your daughter was experiencing the level of distress she described to Oprah Winfrey, would you have expected her to tell you about it? Doria responds, yes. Williams asks, did she tell you she was having suicidal thoughts during her pregnancy? Doria responds, not during the pregnancy. Williams asks, when did she first tell you about having suicidal thoughts? Doria responds, after the Oprah interview was already scheduled. She told me what she planned to say in the interview. Williams asks, so the first time you heard about your daughter's suicidal ideation during her pregnancy was when she told you what she planned to tell Oprah? Doria responds, that is correct. At this point, Meghan's attorney objects on grounds of relevance and instructs Doria not to discuss the content of privileged communications about interview preparation. But the damage is done. Doria has testified under oath that she learned about her daughter's alleged suicidal crisis not when it was supposedly happening, not in the 2 years between the events and the interview, but only after the interview was scheduled and Meghan was preparing her narrative for maximum media impact. This testimony is devastating for multiple reasons. First, it strains credibility to believe that a daughter experiencing genuine suicidal ideation would not confide in her mother, particularly when Meghan has consistently described Doria as her closest confidant. Second, it suggests the mental health narrative was constructed for the Oprah interview rather than being a contemporaneous experience that was later disclosed. Third, it creates potential perjury exposure for Meghan if she testified about these events in other legal proceedings with different details. Fourth, it undermines the emotional foundation of Meghan's criticism of the royal family, because if the crisis was not real or was substantially exaggerated, then the claim that the institution failed her loses its moral force. But Doria's contradictions do not stop with the mental health narrative. The deposition next turns to financial matters, specifically Meghan's claims about being financially cut off by the royal family. In the Oprah interview, Meghan and Harry stated that Charles cut them off financially in the first quarter of 2020, that they were living on money Diana left Harry, and that they had to sign production deals with Netflix and Spotify because they needed income to maintain security and lifestyle. This narrative positioned them as victims of financial abandonment who were forced into commercial ventures by family cruelty. Doria's testimony paints a dramatically different picture. At page 83 of the transcript, Williams asks Doria whether Meghan discussed financial concerns with her in early 2020. Doria testifies that Meghan told her they were planning to pursue entertainment deals and that the financial projections were extremely positive. Williams asks whether Meghan mentioned being cut off or financially desperate. Doria responds that Meghan never used those terms, that she seemed excited about the business opportunities, and that she specifically told Doria they would be making far more money than they ever had access to as working royals. Williams then introduces Exhibit 27, a bank statement from Meghan's personal account at Bank of America showing a balance of $1,472,000 as of March 31, 2020. This is the exact period when Meghan claims they were cut off and financially struggling. Williams asks Doria, did your daughter tell you she had over $1 million in her personal bank account in March 2020? Doria responds, no. Williams asks, did she tell you she was worried about money or unable to afford security? Doria responds, she told me they wanted to hire private security that was better than what the royal family provided, and that they were negotiating deals that would pay for it. She was not worried about affording it, she was excited about upgrading it. This testimony completely contradicts the financial abandonment narrative. If Meghan had $1.4 million in liquid assets in March 2020, she was not financially desperate. if she told her mother they were pursuing deals to upgrade security rather than to afford basic protection. The Netflix and Spotify contracts were opportunistic business decisions rather than desperate necessity. The financial contradictions continue. Williams asks about the Montecito mansion purchase in June 2020. The property cost $14,750,000. Meghan and Harry put down $5 million and financed the remainder. Williams asked Doria, did Meghan tell you where the $5 million down payment came from? Doria testifies that Meghan told her it came from savings and family money. Williams asks, did she tell you Charles gave her that money? Doria responds, no. Williams asks, did she tell you the royal family helped with the purchase? Doria responds, she specifically told me they bought it themselves without any help from his family. This testimony matters because there have been persistent questions about how Meghan and Harry could afford a $15 million property purchase just 3 months after allegedly being cut off financially. Doria's testimony suggests they used their own resources, which undermines the narrative that they were left without support. Now we move to perhaps the most explosive category of Doria's testimony, her statements about the pregnancy and birth of Archie. This area of questioning is so sensitive, so legally fraught, and so central to conspiracy theories that have circulated for years that Meghan's attorneys objected repeatedly and instructed Doria not to answer multiple questions. But enough testimony made it into the record to create serious questions about the official narrative. Williams begins by asking Doria about her involvement in Meghan's prenatal care. Doria testifies that she flew to London in late April 2019 to be present for the birth. Williams asks whether she accompanied Meghan to any prenatal appointments at Portland Hospital. Doria responds that Meghan told her the appointments were private and she did not want anyone present. Williams asks whether Doria was present at Portland Hospital when Archie was born. And here is where it gets extraordinarily significant. Doria pauses for 11 seconds according to the transcript notation. Her attorney confers with her off the record. When testimony resumes, Doria states that she was not at Portland Hospital. Williams asks, where were you when your grandson was born? Meghan's attorney objects on privacy grounds. Williams rephrases. He asks, were you in London when Archie was born? Doria responds, yes. Williams asks, did you go to the hospital where Meghan gave birth? Doria responds, I went to where Meghan was staying. Williams asks, was that a hospital? Another lengthy pause. Meghan's attorney confers with Doria again. Doria responds, I would prefer not to discuss the specific location. Now you need to understand what is happening in this exchange. Doria is Meghan's mother. If Meghan gave birth at Portland Hospital as publicly claimed, there is absolutely no reason Doria would be unable or unwilling to confirm she went to Portland Hospital to see her daughter and new grandson. The fact that Doria cannot or will not confirm the hospital location suggests something about the birth narrative is not as publicly presented. Williams pursues this. He asks, did you see Meghan in a hospital bed after she gave birth? Meghan's attorney objects and instructs Doria not to answer questions about Meghan's medical condition or location during childbirth, citing medical privacy protections. But Williams has already established what he needed to establish. Doria cannot or will not confirm the basic facts about where and how her grandson was born, which is exactly what would happen if the official narrative contains elements that cannot withstand sworn testimony. Williams moves to questions about Doria's time with the newborn baby. He asks, how many hours after birth did you first hold Archie? Doria responds that it was several hours. Williams asks, was this because of hospital protocols or other reasons? Doria responds that she does not recall the specific reasons for the delay. Williams asks, when you first held Archie, did he appear to be a newborn who was just hours old? Meghan's attorney objects on grounds that Doria is not a medical expert qualified to assess infant age. Williams withdraws the question and asks instead, how long did you stay in London after Archie's birth? Doria responds approximately 2 weeks. Williams asks, during those 2 weeks, did you stay at Frogmore Cottage with Meghan and Harry? Doria responds that she stayed nearby but not in the same residence. Williams asks why not, and Doria states that Meghan and Harry wanted privacy to bond with the baby. This sequence of answers creates a peculiar picture. Grandmothers typically stay with their daughters immediately after birth to provide support during recovery. The fact that Doria stayed in separate accommodations and did not have immediate access to the baby contradicts normal family behavior after a first grandchild's birth. Williams recognizes this and asks directly, "Was there a reason you were not given unrestricted access to your daughter and grandson during the immediate post birth period?" Meghan's attorney objects on relevance grounds. Williams argues that Doria's access and observations are relevant to questions about the birth circumstances that are at issue in the litigation. The attorneys go off the record for 17 minutes to discuss the objection. When they return, Meghan's attorney maintains the objection and Doria declines to answer. The deposition then shifts to questions about Archie's appearance and characteristics that Doria observed during her 2-week stay. Williams asks, "When you held Archie, did you notice whether he resembled Meghan as a newborn?" Doria responds that she saw some resemblance. Williams asks, "Did you notice whether he resembled Harry or members of Harry's family?" Doria responds that newborns change quickly and it was hard to tell. Williams asks, "Did Meghan show you Archie's hospital identification bracelet or birth certificate?" Doria responds that she does not recall seeing those documents during her visit. Williams asks, "Did you take photographs with Archie during your stay?" Doria responds that Meghan requested they limit photographs for security and privacy reasons. Williams asks, "Did Meghan tell you why she wanted to limit photographs of the baby, even from his grandmother?" Meghan's attorney objects, and Doria declines to answer based on the objection. What emerges from this testimony is a pattern of unusual secrecy, limited access, and inability or unwillingness to confirm basic facts about a birth and newborn period that would normally be straightforward and joyful for a grandmother to discuss. If Archie was born via normal delivery at Portland Hospital and Doria spent 2 weeks with her daughter and grandson, she should be able to easily confirm where the birth occurred, describe her immediate access to the baby, recall seeing hospital documentation, and discuss photographs without hesitation. The fact that she cannot or will not confirm these basic elements supports the questions that skeptics have raised for 5 years about whether the official birth narrative is complete and accurate. The deposition continues into questions about Lilibet's birth in June 2021. Williams asks whether Doria was present for Lilibet's birth at Santa Barbara Cottage Hospital. Doria responds that she was in California during that time. Williams asks whether she was at Santa Barbara Cottage Hospital when Lilibet was born. Doria responds that Meghan wanted a very private birth experience with just Harry present. Williams asks, "So you were not at the hospital when your granddaughter was born?" Doria confirms she was not at the hospital. Williams asks, "When was the first time you held Lilibet?" Doria responds it was 2 days after the birth. Williams asks, "Why 2 days rather than immediately?" Doria responds that Meghan was recovering and wanted time alone with the baby first. Williams asks, "When you first held Lilibet, did she appear to be a 2-day-old newborn?" Meghan's attorney objects on the same grounds as before, that Doria lacks medical expertise to assess infant age. Williams rephrases and asks, "Based on your experience as a mother and grandmother, did Lilibet appear to you to be a newborn who was approximately 2 days old?" Meghan's attorney maintains the objection and instructs Doria not to answer. Williams then asks after Lilibet's birth, "Did you have unrestricted access to visit your daughter and granddaughter, or were there limitations?" Doria responds that she visited several times, but by appointment. Williams asks, "By appointment with your own daughter to see your newborn granddaughter?" Doria responds that Meghan and Harry maintained strict privacy protocols and preferred scheduled visits. Williams asks, "Did they maintain these same strict privacy protocols with Harry's family?" Doria responds that she does not know what arrangements existed with Harry's family. Williams asks, "To your knowledge, did Charles or William or other royal family members visit to meet Lilibet in the weeks after her birth?" Doria responds that Meghan told her no members of Harry's family had visited. Williams asks, "Did Meghan tell you why Harry's family did not visit to meet their granddaughter and niece?" Doria responds that Meghan said they did not ask to visit. This testimony about Lilibet's birth and the post-birth period creates the same pattern of unusual access restrictions and scheduled visiting arrangements that would be atypical for a grandmother's relationship with a newborn grandchild. Williams pursues this by asking, "Did you find it unusual that you could only visit your newborn granddaughter by appointment?" Meghan's attorney objects on relevance. But Williams argues that Doria's observations about access restrictions are relevant to understanding the family dynamics and credibility of claims about relationship quality. The judge who will eventually rule on discovery disputes has not yet resolved this objection, but the question has been asked and recorded. Let us pause here to recognize what we have established so far. We have a mother testifying under oath that her daughter's claims about suicidal ideation during pregnancy were first disclosed only when preparing for a lucrative media interview. We have a mother testifying that her daughter's claims about financial desperation contradict what she was actually told about business opportunities and existing resources. We have a mother unable or unwilling to confirm basic facts about where and how her grandchildren were born, describing unusual access restrictions, and declining to answer questions about newborn appearance and characteristics. Each of these categories independently creates credibility problems for Meghan. Collectively, they suggest a pattern of narrative construction that prioritizes media impact and financial benefit over accuracy and truth. Now we move forward in the deposition to questions about specific statements Meghan has made in interviews, books, and legal filings. Williams methodically walks through claims that Meghan has made and asks Doria whether those claims match what Meghan told her at the time or whether Doria has direct knowledge contradicting the claims. This section of testimony consumes over 90 pages of transcript and addresses dozens of specific assertions. We will focus on the most significant contradictions that have legal consequences. The first area involves Meghan's claims about racism within the royal family. In the Oprah interview, Meghan stated that there were concerns and conversations about how dark Archie's skin might be when he was born. This claim generated international outrage, prompted accusations of racism against the royal family, and became central to Meghan's explanation for why she and Harry left the institution. Williams asks Doria, "Did Meghan tell you at the time that members of the royal family expressed concerns about Archie's potential skin color?" Doria responds that Meghan told her some people in Harry's life had outdated views about race. Williams asks, "Did Meghan specifically tell you that someone expressed concern about how dark Archie's skin would be?" Doria pauses and responds, "She told me there were conversations that made her uncomfortable about race and identity." Williams asks, "Did she tell you specifically that someone said they were worried about dark skin?" Doria responds, "I do not recall her using those exact words when she told me about it." Williams asks, "When did Meghan first tell you about these conversations?" Doria responds that it was after they had moved to California. Williams then introduces Exhibit 41, which is a text message exchange between Meghan and Doria from November 2019. In this exchange, Meghan complains about media coverage and palace protocol, but makes no mention of racism or skin color conversations. Williams asks, "If Meghan had experienced racism from Harry's family regarding your grandson's skin color, would you expect her to mention that to you?" Doria responds, "Yes." Williams asks, "But she did not mention it in this November 2019 conversation?" Doria confirms she did not. Williams asks, "When she later told you about conversations concerning race, did she identify who made these comments?" Doria responds that she said it was family members, but did not name specific people. Williams asks, "Did she tell you Harry was present during these conversations?" Doria responds that she does not recall whether Harry was present or whether Meghan heard about the conversations from Harry. This testimony creates significant problems for the racism narrative.